Chapter 9. Into the unfolding drama came a man with two first names. David Allen was relatively new to criminal law. He was 36, with thick, receding black hair, a pear-shaped face, recessed chin, and small dark grey eyes that hid behind 80s-styled silver, wire-rim glasses. His thick lower lip was offset by a short upper one that caused his mouth to remain open most of the time. It made him look like he was about to speak when he wasn't. Typically, he wore grey wool suits to match his eyes. He thought he shook things up from time to time when he wore a maroon or black shirt instead of his normal light blue. David graduated from McGeorge. He started his career as an associate at a Sacramento law firm specializing in personal injury and workers' compensation. Personal injury practice, he found, was a crapshoot due to its use of contingent fees. In the contingent fee arrangement, a lawyer typically puts up their own money to build the client's case. In return, the clients agree to give the lawyer a large percentage of any recovery to offset the gamble. The art of the practice is to know the value of the injury and not spend more than it's worth, or that you can afford to lose. Cases can easily last more than a year. If there's no payoff, you eat the expenditures. Ambulance chasers is what people used to call these lawyers before the state bar prohibited them from contacting potential clients who didn't contact them first. That led to television commercials, billboards, and all manner of ads as lures that used the phrase, "If you get nothing, we get nothing." It was a consumer warning disguised as a benefit, meant to protect the vulnerable from unscrupulous opportunists and liars, the latter of which, if you say slowly enough, is how Texans pronounce the profession. The second area of practice, workers' comp, is a statutorily controlled colossal morass of paper shuffling for a small set fee, meant to help people injured on the job. Who needs a doctorate degree to do this, is how David looked at it. It has miserable, often thankless clients, banging their heads against the brick walls of insurance bureaucracy and actuarial tables that value sight, arms, legs, sex, walking and pain far less than clients do. You need a lot of clients to make this area of practice worth the work and headaches. David's gut told him that staying on that firm's professional path would only lead to alcoholism and a one-bullet dose of self-help to stop the misery of wondering where he went wrong with his choices all those years ago. He thought he was cut out for better things. So, he quietly put out applications to work as an entry-level deputy district attorney to 6 counties, hoping for a big change with some job security and a steady paycheck. Monterey, Santa Cruz, Ventura, San Diego, and South Lake Tahoe had all thanked him for his application, but provided no other encouragement. His application to Tulare County had been an afterthought. He'd heard an urban myth that if you had to live anywhere in the Central Valley, Visalia was the best place to be. And that was what he told his wife after he received a telephone call from the Tulare County District Attorney's office to schedule an immediate job interview. Tulare County had an opening for an entry-level deputy district attorney because of a recent unpublicized sexual harassment problem involving 2 deputies, Ed Gill and Jennifer Amadio. Ed was a 42-year-old overweight Mexican who lasted his way, rather than worked his way up the ladder to mid-level supervisor in the 8 years he'd been in the office. He had a big ego, a mediocre skill set that tended to rub his opponents the wrong way, and a below-average win record. He imagined himself being a top man in local Hispanic politics, enjoying the thanks and praise of his people, not thinking what he could do to earn it. He dreamed of making it to Sacramento, maybe as a representative, or better yet, a state senator. Recently, he had taken to slicking his thick black hair with products and wearing cologne in the office. He thought it was being well received by his co-workers, especially the ladies. Jennifer was a well-educated 32-year-old, self-aware, attractive, and fit brunette with a quick, analytical mind. She had transferred in from the DA's office in Los Angeles for personal reasons related to a failed engagement, and because a Level 1 Deputy DA in Tulare County was the only Deputy DA job immediately available on the job search sites at the time. She had a genetic gift of uniquely grey-blue irises, darkly encircled with large eyelashes accentuating her slightly tilted eyes. She was disciplined. She kept in shape with a ritual that started every morning with tea, yoga, and a playlist that lately started with Seashore by The Regrets. After a year on the job, she had no illusions. She was the smartest person in that office. It was so top-heavy with entrenched lifers, she would need years to get to a position she was worthy of, waiting for those above her to retire, die, or buy their way into a judgeship through political favors or friendships with local money. She had endured the small town, low aspirations, and bleak conversations of her co-workers, whose intolerable backyard parties bordered on fraternity keggers and included open drug abuse, mostly cocaine, and occasional drunken debauchery. She felt she was entitled to a change and was looking for a way out. She found it the first day she smelled Sauvage by Christian Dior emanating from Ed Gill's office. Jennifer immediately switched to wearing slightly higher hems on her skirts to show a little more leg and left one more button open on her blouse when she was not in court. She stopped wearing comfortable utilitarian bras, switching to sheer lace ones from sextoys.com that allowed her large areola and nipple to barely show through her blouse's silky fabric. She extended her eye contact by only a second when Ed walked past her desk. She only had to ask him twice to look at a court file for her and then endure his completely unnecessary advice to get what she wanted. He asked her out. Jennifer responded coyly, "Thank you. No, I'm not dating." The next day she wore a tight-fitting, full-body, metal grey sweater dress and strappy black leather shoes. Towards the end of the day, Gill had asked her innocently if she was sure. Wouldn't she like to do something outside the office together? He suggested maybe they could meet for drinks. She told him she was going through some personal things. He asked, self-servingly, and as social habit, if there was anything he could do to help. She answered, "No, and thank you," a second time. That was a Friday. On Monday, she went to see his supervisor, Kathy Montejano, explaining she had thought about it over the weekend and was troubled by the attention that had crept up from Ed Gill. She didn't want to cause problems in the office, but she had clearly told him no, and he had asked again. She was afraid this would interfere with her job. Kathy, out of lazy ignorance, or a chance to fly the "we stick together girl" flag, had assured Jennifer she had done the right thing coming to her. There was nothing to worry about. It would be taken care of. Jennifer sent Kathy an email that same day, thanking her for her help and guidance. Jennifer worked through the uneventful week, looking forward to the weekend. On Saturday, she went to Rodeo Drive in Los Angeles and shopped. She stayed the night in the Wildflower Suite at Hotel Bel Air, meeting friends in the bar and lounge, examining her future. Paris. She had never been to London. Belize would be nice, but there was no legal work there. Not North Carolina. She would visit her parents on holidays, that was enough. In her mind, the $2,400 she had just spent on a black Italian silk skirt that hugged her waist and hips in form-fitting, seamless cloth that fell dripping in pleats and flittered around her, like fingers waving, "Come hither," was a small investment. She could use it later when she wanted what it beckoned. This is going to be easy, she thought. No touching, no sex, no kissing. Just heat him up and let his ego boil over. Sexual harassment only requires one notice to the appropriate supervisor that something inappropriate has happened and an opportunity for the employer to intercede and tell the offender to stop. If the offender acts out one more time after that, it's actionable harassment. Ed's growing fantasies and his ego's need to be convinced he couldn't coax her into a simple meeting outside the office was all the match she needed to light the settlement money fuse she'd created. On Monday, she wore the black silk skirt to work. When the opportunity arrived, she bent over a co-worker's desk directly in Ed's line of sight, right up her main street, and let it wave, "Come hither." He called her that night to discuss the situation. The call was straightforward. He apologized for being too forward. He told her he found her attractive. She said that was nice, but again, she was not interested. She let the phone call last a few more minutes of small talk, then said goodbye. The next day, she didn't show up for work. A mid-morning call from her newly hired LA lawyer to Kathy Montejano's supervisor exposed the continuing unwanted harassment after an official complaint had been made, as evidenced by her email. The harasser's phone call could be proven by phone records and put a glaring light on the office's failure. Her lawyer made it clear Jennifer, both for her and their sake, wasn't going to make a public statement about the full content of Ed's call at this time. She was too upset. Whatever she said wasn't going to be good for them. Any denial by the DA's office was just going to worsen the situation and lead to public scrutiny, or perhaps a trial, exposing that office's dysfunction spread far and wide by the media. Her lawyer quickly spun the situation into his client's distress, causing her to fear coming back to work, emphasizing the permanent impact this was going to have, ruining her future career as an upcoming successful deputy district attorney. A smart, beautiful white female DA harassed by a Mexican male supervisor. And him, pressuring her unwilling consent, maybe as a precursor to employment advancement, after he knew or should have known to stop because of her prior complaint. It was only a little worse than falsifying evidence against a defendant to the voting public. A $400,000 settlement with non-disclosure agreements was reached in 17 days, with additional pay for time off, before she officially left the office. Jennifer spent the entire time packing and putting her things in storage. A personal letter from the elected district attorney was put in her personnel file, extolling her as one of the finest lawyers that office had ever had the privilege to work with. It expressed their regrets at her leaving based on her decision to explore other areas of her profession. It ended stating their absolute willingness to have her back at any time. She moved to Florence, Italy, to review her options. Ed got a closed-door firing that amounted to telling him he had requested a leave of absence for 30 days for health reasons, which they were granting, and if he didn't quit during that time, he would be fired. He found an entry-level DA job in Madeira, California. Into that vacuum, David Allen's timely application landed on top of a dusty stack. He was interviewed and hired the following Tuesday. David started out in juvenile court while the office was undergoing some reshuffling. He spent a year working with Human Services and Child Protective Services before being transferred to the Adult Criminal section. Moving quickly through the various duties of tending misdemeanor calendars, he made his way into felonies. David had never handled a murder case. The practice in that DA's office was to allow upcoming deputies to cut their teeth on murder cases that were not factually difficult or legally technical. Cesar Navarro's case had been reviewed by the supervising committee, which concluded Navarro was a very simple case for prosecution, perfect for a first-time deputy, first degree, no offers, plead or go to trial. It didn't matter which.